Yes, Mr. Sir.
My Lords, there's a straightforward answer to ST's appeal under grounds 1, 3 and 4, and it can be expressed in these 4 short propositions, which I will develop in my submissions. First, a foreign judgment which has not been recognised by the English court has no legal effect in this jurisdiction. Secondly, if the holder of a foreign money judgment wishes to have it enforced in this jurisdiction, then at common law he must first bring an action on the judgment with a view to the English court recognising it and enforcing it by giving an English money judgment. And it is that English money judgment which can then be enforced here, including by bankruptcy proceedings. Thirdly, at the time that ST presented its petition to bankrupt Mr. Drelle, the Russian money judgment, the sole basis for its alleged petition debt, had not been recognised and enforced here by the English court, with the consequence that it had no legal effect here. And fourthly, my lords, it follows that the Russian judgment and any sum awarded under it were incapable of supporting a bankruptcy petition. My lords, the basic roadmap for my submissions in developing those propositions, and which will involve addressing ST's arguments as appropriate, is as follows. First, I will address your lordships on the dicey rules and the common law and on the recognition and enforcement of foreign judgments. Secondly, on the requirements for a petitionable debt within the meaning of section 2672B of the 1986 Insolvency Act. Thirdly, and briefly in the light of my learned friend's submissions yesterday on the 1933 Act and re-adjudgment debtor. And fourthly, and finally, on the obligation theory. My lords, I turn to the dicey rules. The start point, my lords, is dicey rule 45, you weren't taken to yesterday, which your lordships find at 1848 of the bundle. And I would invite your lordships just to remind yourselves of that. Judgment of a court of a foreign country, hereinafter referred to as a foreign judgment, has no direct operation in England, but may be enforceable by claim or counterclaim at common law or under statute, or be recognised as a defence to a claim or as conclusive of an issue in a claim. And then, my lords, Rule 46.1, which you were taken to by my learned friend yesterday at page 1856 of your lordship's bundle, my learned friend read out to your lordships Rule 46, including the requirements for international jurisdiction and lack of impeachability in the first main paragraph, and then the two other requirements in A and B, but he didn't mention the important words, but not otherwise. And your lordships see that Rule 46 complements Rule 45. And my lords, there are 5 points which flow from those 2 rules, and they are these. First, that a foreign judgment has, as such, no direct operation or legal effect in this jurisdiction. And as we set out in our written case at section B1, paragraph 7 following at page 70, that follows from the limited territorial effect of foreign judgments, which are themselves regarded as an exercise of state sovereignty, and it's an internationally recognized principle that one sovereign state should not trespass upon the authority of another. My Lords, the second point is that a foreign judgment is and can only be given effect in this jurisdiction by the two routes set out in Dicey Rule 45 and 46(1) and 2. So, where the foreign judgment is intended not to be used defensively as a shield, but to be enforced, then the only route is the common law action on the judgment, as stated in Rule 45(1), and as made clear from 46(1), those final words, or registration under a statute if the foreign judgment falls within one of the registration schemes under the 1920 or 1933 Acts, or where the foreign judgment is intended only to be used defensively, then simply by being recognised as conclusive. My Lords, the fact that the unrecognised foreign judgment is enforceable only by the action on the judgment has been confirmed time and time again in numerous cases, including decisions of this court, as well as in legal works, as set out in paragraphs 21 to 22 of our written case at pages 73 to 75 of the bundle. Of course, once the English judgment has been obtained in the common law action on the judgment, then the full suite of enforcement procedures available to the now English judgment holder are available, and those include bankruptcy proceedings, of course. And so, my Lords, when Lord Justice Snowden, as he then was, said, your Lordships could perhaps turn this up, please, at page 149 in the judgment below, at paragraph 62, when he said that an unrecognised or unregistered foreign judgment cannot be enforced for the individual benefit of a successful litigant using any of the processes of the English court, he was entirely right with respect to say so. And of course, he was not confining enforcement to execution. My Lords, the third point is that at common law, the foreign judgment is only ever given legal effect via the intermediation of the English court. Whether the foreign judgment is sought to be enforced, or whether it is only relied upon defensively, in both cases, the necessary precondition is recognition by the English courts. And if your Lordships could please go to 1848, which is the same page as Dicey Rule 45, your Lordships see what's said in the commentary at 14002. Foreign judgment has no direct operation, and so on.
Just while we're on that,
yes,
the meaning of direct operation, what it says then in the second sentence, it cannot be immediately enforced by execution.
Yes, my Lord.
That's what we're concerned with, isn't it?
No, my Lord. That is simply an example of enforcement. Dicey Rule 45 is not confined to processes of execution. It proceeds on the basis that the foreign judgment has no direct operational legal effect, and it must, if it's to be enforced, as I've said, proceed via the action on the judgment. One then gets an English judgment, and then the full suite of available remedies, including execution or bankruptcy proceedings, is available. Lords, in the rest of that paragraph, you'll see that the editors go on. Last sentence, it's plain that while a court must recognise every foreign judgment which it enforces, it need not enforce every foreign judgment which it recognises. My Lords, the fourth point is that the English court will not recognise and enforce the foreign judgment unless the English court is satisfied, first, that the foreign judgment the foreign court had international jurisdiction over the defendant under Dicey Rules 47 and 48, as referred to Rule 46. And secondly, so it's a twofold requirement, secondly, that the judgment is not impeachable under any of dicey rules 52 to 55, one of which, of course, includes that the judgment may be impeachable for fraud. And, my lords, the fifth point is that these rules draw no distinction between different types of foreign judgment, whether concerned with the enforcement of private or sovereign rights. My lords, in addition to rules 45 and 46, I propose to take your lordship to just 4 materials, 2 cases, 1 academic text, and the Greer Committee report as further illustration of the points I've made. My lord, the first authority is a decision of this court in the Madeiro board case, lordships will find, if I can take you to, at 717. But if your lordships, and just to remind your lordships, in that case, Mr. Maduro claimed that he'd won the 2018 presidential election. Mr. Guaido disputed that. Mr. Guaido was confirmed as Venezuela's legitimate interim president by a transition statute passed by the Venezuelan National Assembly. And HMG recognized Mr. Guaido as the legitimate interim president. However, the Venezuelan Supreme Tribunal of Justice gave several judgments that the transition statute was null and void. And so the issues in this court included whether the transition statute was protected from examination by our courts because of the Act of State doctrine, and secondly, the status and effect of the Venezuelan Supreme Tribunal judgments. And my lords, first please at page 724, at paragraph 157, Lord Lloyd Jones, with whom the rest of their lordships, including my Lord Hamblin, agreed, said, although judicial rulings of a foreign state are manifestations of state sovereignty, it's now clear they do not themselves attract the operation of any rule of foreign act of state applicable in this jurisdiction, and, as a result, are not entitled to the deference which may be shown to legislative and executive acts of a foreign state. So, my lords, contrary to the submissions which were made yesterday, a judicial ruling of a foreign state is itself an exercise of sovereign power, even when it determines a dispute between non-state parties determining private claims. And then, my lords, at paragraph 159 on the same page, as a result, courts in this jurisdiction are more willing to investigate whether a foreign court acting in a way that meets the standards expected of a court and whether there's occurred or is likely to occur a failure of substantial justice. And in this, for this reason, foreign judgments fall to be assessed under different rules from those applicable to legislative and executive acts and are simply less impervious to review. And the well-known dicta of Lord Justice Ricks in UKOS Capital No. 2 are cited with approval. And then, please, my lords, over the page to 725, and you were taken to this yesterday at letter B. Courts, however, are always responsible for their acts, both domestically and internationally. Domestically, they're responsible up to the level of their Supreme Court, and internationally, they are responsible in the sense that their judgments are recognizable and enforceable in other nations only to the extent that they have observed what we would call substantial or natural justice, and what internationally is more and more being referred to as the rule of law. And then, my lords, at the bottom of that page, please, paragraph 161, Lord Lloyd Jones says this: there is therefore no rule requiring an unquestioning acceptance by courts in the United Kingdom of the validity or legality of a foreign judgment. Rather, the status of a foreign judgment is left to be determined in accordance with domestic rules on the recognition and enforcement of foreign judgments. And then, my lords, please, at page 728, paragraph 169, between letters D and E, furthermore, although judicial acts of that foreign state do not enjoy before UK courts the protection of any such rule of law of non-justiciability, it may, in certain circumstances, nevertheless be appropriate to recognize or give effect to them in accordance with domestic rules of private international law. Then, my lords, at the bottom of that page, finally, at 170, the focus of the present case, therefore, shifts to the status of the judgments of the Supreme Tribunal of Justice on which the Maduro Board relies. These judgments do not themselves attract the protection of any act of state rule. The question becomes whether, and if so, to what extent, they should be recognized or given effect by courts in this jurisdiction. And it was necessary, my lords, to remit that question to the commercial court to resolve. So, my lords, just as it was necessary in that case for the commercial court to consider what status should be given to the Supreme Tribunal of Justice's judgments and to decide by applying our domestic rules of private international law whether they should be recognized and given effect in this jurisdiction, so too here it was necessary for the Russian judgment, as providing the sole basis for the petition debt, the alleged petition debt, to be considered by the High Court in the same way. And if and only if the English court held in an action at common law that the Russian judgment should be given effect and recognized and then enforced by the making of an English money judgment, would ST then have been in a position to present a bankruptcy petition, and of course based on an English money judgment, a point which I will come to. My lords, secondly, I would like please to show your lordships...
Can I just test that last point?
Yeah.
I mean, what I think you're saying is that those issues which might be loosely and inelegantly summarized as competent jurisdiction and impeachability, you say have to be dealt with in an action in the High Court and can't be addressed in any other way by the court, e.g. by a court deciding whether there's a real dispute about the underlying obligation as a reason for not making a bankruptcy order.
In the case of a foreign money judgment, in the case of where it is sought to enforce the judgment, that is correct. Yes.
But yes, that's your submission.
That is my submission.
But where do you get that from?
Well, my lords, I get that...
You get it from Dicey 46, where he just says, well, it can only be done by an action and not otherwise, because it's an aspect of enforcement.
That is precisely 5, and that is precisely so, and Rule 45. And also, my lord, this brings into play the point that, which I'll come to, that the Russian judgment had to have been recognized in the way your lordship has said before or at the time of presentation of the petition, because that is the statutory requirement as at the time of presentation in section 2672B. But I get that from what your lordship put to me, from those Dicey rules, and from what Lord Lloyd Jones has said, and I'll come on to another case, because in the Maduro Board case, the question was, because the Supreme Tribunal of Justice had declared the transition statute void, and that wasn't one of the preliminary issues before your lordships to be decided in that case, there was a remission to the commercial court to decide whether the Supreme Tribunal of Justice's judgment should be recognised and given effect. That's to say, given legal effect. Until that time, until there was recognition, until the requirements of 46.1 and 46.2, which concerns just defensive use, unless those requirements of did the foreign court have international jurisdiction over the defendant, is the judgment unimpeachable, unless those were determined in favour of the holder of the judgment, then the judgment is not recognised and is not given legal effect. My Lords, the second...
Is there any difference in practice between those issues being determined in the bankruptcy proceedings and in an action?
Yes, my Lord, I'm going to come to that.
If you could give me a sketch now.
I will give you a sketch now. The first point is the maid I made in answer to my Lord Briggs, which is that the critical time is the date of presentation of the petition, so that if it...
Looking for a practical difference between the two processes.
Well, the bankruptcy court is not the court for resolving or adjudicating upon rights. As has been said by this court, it's to do with enforcing liabilities.
But if there is a triable issue about it, well, then you have to go down a different path.
Yeah. I mean, the bankruptcy court regularly adjudicates on the question whether there's a tribal issue which requires to be litigated in the High Court or County Court or wherever, in court,
yes.
proceeding with bankruptcy, and only proceeds with bankruptcy if there isn't.
Yes,
What's the principal reason for having to adopt your process? Your suggested process?
First of all, it's what statute requires. And secondly, recognition is a substantive matter. It is not procedural. It goes to the substance. Because otherwise, when you get to the time of presentation of the petition, one has a judgment which is of no legal effect. One is coming along with a nothing, and one can't proceed on the basis of that. Those are the two substantive reasons why, my Lord. My Lord, then, in relation to...
I think I can understand why the petitioner would himself be required to show, in order to get his petition off the ground, that the foreign judgment was made by a court of competent jurisdiction. But it's a slightly upside-down exercise to think that he's also got to show it's unimpeachable.
Well, my Lord...
Take a case where the bankrupt isn't opposing. He's just got to satisfy the court that it's a proper case to make a bankruptcy order. He's having to prove a sort of negative when nobody has come up with any reason for impeachment.
My Lord, there has to be some ruling of the English court recognising and giving effect to the foreign judgment, however that may take place, before the petition is presented.
Well, that's your assertion, and we're just lightly asking why.
Well, because, my Lord, Section 267(2)(b) requires that there be a debt, that there be something payable at the time of presentation of the petition. And, my Lords, at the time of presentation of the petition, because the English court has not recognised or given effect to the judgment, it follows that it is of no legal effect, and similarly, any sum under it, awarded under it, is a nothing. That is the...
Totally coherent with the ability of a person to petition for bankruptcy on the basis of a foreign debt which hasn't been subject to adjudication. Namely, this is a contract, you're in breach of it, you owe us money, and here you are.
My Lord,
Totally coherent with that.
Well, there are two different matters with respect, my Lord, because the example your Lordship gives proceeds by way of a contract between private parties. In this case, there is no such contract. There is a foreign judgment, and it is precisely because foreign judgments are adjudications of a foreign state, and that they are therefore only given effect in this jurisdiction if they are recognised and if the court is satisfied that there is a different matter. And impeachability, my Lord, is a precondition to recognition, as I will come on to show when I take your Lordships to the third authority, which I will come to presently. My Lords, moving on, unless your Lordship had
Well, I'm just asking myself, if your point is that the Bankruptcy Act requires there to be a relevant debt, but if the cases on obligations show that there is a relevant debt from a foreign judgment, providing it's made by a court of competent jurisdiction, as long as it's not impeachable, if no suggestion of impeachability, let's assume no suggestion of impeachability is being made. I know it is in this case, but that's a separate issue. Why should the existence or otherwise of the debt depend upon the creditor demonstrating unimpeachability when nobody's suggesting it is impeachable?
My Lord, can I come to that? I'm going to address that point when I come to the obligation theory. But the short point is the theory was developed at a particular time because of the forms of action. And the theory was developed to explain and only explain the basis for the action at common law. It has no other purpose than that. Can I come to that in due course? My Lords, the second authority I wish to show you, Lordships, is what Professor Briggs says in The Conflict of Laws, which your Lordships will find at page 1368, the relevant passage, under the heading Recognition and Enforcement. And Professor Briggs writes, although interest in foreign judgments is most concerned whether a foreign judgment can be enforced in England, there's a question which, for the common law, at least precedes it. This asks whether the foreign judgment will be recognised or recognised as res judicata, which is to say, as a matter which has been adjudicated. For the common law cannot allow the enforcement of a judgment which it does not first recognise. And then on to the second paragraph, recognition of a foreign judgment means treating the matter which was adjudicated by the foreign court as having been determined conclusively once and for all. And then, my Lords, 4 lines on, the material question will be whether the common law considers that person to be under an obligation to abide by the judgment given. And this perhaps feeds into my Lord's point. And as I say, I'll come on to the obligation theory as deployed by ST in its ground 1 in due course. But it's worth noting here that Professor Briggs's interpretation of the obligation theory is that it is recognition that determines whether, in fact, there is the obligation. And that is...
He does, and he bases it on Clark and...
Coming to that.
No Scando. You're coming to that.
I'm coming to that. That is my third authority, absolutely. And then, but before I do, if your Lordships can also please go to page 1355 in your Lordships bundle, that is that is part of the Law Quarterly Review from 2013 when Professor Briggs was writing, a bit earlier. And he says on that page, 2 lines down, but where the common law...
I'm so sorry, I've got the page number wrong.
Yeah, I think I... Can you find where the common law belonged? Sorry, third paragraph. It's the same page, third paragraph.
Same page?
Same page, third paragraph, second line. But where the common law governs the question, the understanding for at least 140 years has been that the foreign judgment, if it is recognised, imposes an obligation on the party against whose interest it is to be asserted.
I'm so sorry, Mr. Howard, which is the bundle page number you're on?
1355, my Lord.
Thank you.
And it's the third paragraph, and it's the second line. It's that...
And he relies upon...
Would you
Goddard and Gray.
Yes, because that's right, as it's since been developed, effectively, as it's been brought into modern times. But the key point is the obligation arises if the foreign judgment is recognised. And then, my Lord, making the obvious point, the Russian judgment, at the time the petition was presented, and so it remains, was not recognised. Lord, then back to the conflict of laws, please, at 1369. and this is the last paragraph on that page, 2 lines down. Do my lords have that? If the claimant obtained judgment in respect of the whole of the claim, she may wish to go beyond recognition to bring proceedings which have the effect of enforcing the judgment, say by demanding payment of the sum which the foreign court ordered to be paid and which remains unpaid. If it is to be enforced at the behest of the successful party, the foreign judgment must first be recognized, then satisfy further conditions. If this is successfully done, the English court will give its own judgment in the claimant's favour, which she may enforce as an English judgment because it is an English judgment. So, my lord, this makes clear that if ST wanted to enforce the Russian judgment...
This is Briggs again, is that right?
Yes, my lord, it is. Conflict of laws, my lord, yes. So this makes clear, my lords, that if ST wanted to enforce the Russian judgment, including by petitioning, based on the sum awarded under it, it first needed to obtain, by bringing the common law action because it was seeking to use the foreign judgment offensively as a sword, pursuant to Dicey Rules 45 and 46, recognition of that Russian judgment, and then an English judgment and order for payment. Now I come to Clark and Fenner-Scandia, which your lordships find about 548 of your lordships' bundle. My lords, what Professor Briggs has expressed regarding the necessary prior condition of obtaining recognition has been endorsed at the highest level by the House of Lords in this case. In that case, and the facts are important, Mr. Clark sought a declarator that US money judgment... Declarator that US money judgments for costs in favour of Fenner-Scandia, following his failed claims in conspiracy against them, were not recognisable and enforceable in Scotland because they had been obtained by fraud. Lord Roger gave the sole judgment, with whom Lords Bingham, Hope, Walker and Newburger agreed. My lords, at 552, having referred in paragraph 18 to the pursuer's reference to Professor Briggs's The Conflict of Laws and Professor Briggs's explanation of recognition, over the page at 553 paragraph 21, Lord Roger said this: "My lords, I am happy to accept that in the words of Professor Briggs, the logic of the law is that recognition is the necessary primary concern," referencing the conflict of laws, and that was then the first edition. "I also accept that recognizing a judgment entails the court treating the relevant claim as having been determined once and for all by the foreign court. Hence, any question as to the possible effect of fraud would properly fall to be considered at the recognition stage." And at paragraph 22, Lord Roger says that in that case, because there was no risk of the court being asked to enforce the American orders because of undertakings given by the defenders, the court had no need to consider whether the American orders should be recognized, and just looking at 4 lines down in 22, as a preliminary to deciding whether to grant interdicts, I hope that's, to stop the defenders from taking steps to enforce them. So the question whether the foreign judgment, and this is a foreign money judgment case, so the question whether the foreign judgment might be impeached, including for fraud, is something which is to be considered, must be considered and ruled on when determining what effect should be given to the foreign judgment and whether it should be recognised.
And that was a case where there was a serious allegation being pursued at the highest level that the foreign judgment had been obtained by fraud. One which, had there been a bankruptcy petition based on the foreign judgment, would have led, one assumes, the bankruptcy court saying, well, it's a tribal issue like this, you can't have a bankruptcy. Well, go and get your judgment recognised in court so as to deal with that challenge. But we're... I'm not sure that these dicta arising out of that situation answer the question whether recognition is an essential prerequisite for a bankruptcy petition.
Well, Lord, recognition is the essential prerequisite before the court decides that the foreign judgment has legal effect. And if it is the case that a bankruptcy petition is presented at a time when the foreign judgment, being the sole source of the sum which is said to found the basis of the petition, has not been given legal effect by the English court, there is then no debt in English law, and certainly there is nothing payable in English law, my lords, because otherwise one is jumping ahead and treating the foreign judgment as having been recognised when it has not. My lords, and I should add this, the other point of recognition is that if the court recognises the foreign judgment and gives it effect, it then has the effect of also being treated as conclusive as between the parties. And that is why Dicey Rule 46.2 is expressed in the way it is in relation to res judicata matters arising. My lord, the fourth material I wish to show you, lordships, is the Greer Committee report. And your lordships find that at page 1455, and we refer to that, just for your lordships' references, in footnotes 17 and 34, respectively, at pages 73 and 80 of our written case. My lords, the report was produced by a committee headed by Lord Justice Greer, and which advised on what became the Foreign Judgments Reciprocal Enforcement Act of 1933. I'll come back to this report later also when addressing your lordships on the 1933 Act, but it's relevant now at this stage because it sets out what was and what the Greer Committee plainly understood was the common law position regarding the recognition and enforcement of judgments. My lords, the committee produced a draft bill which was substantially identical to what Parliament enacted by way of the 1933 Act, suggesting that what the Greer Committee understood to be the common law position, at least as regards plaintiffs' foreign money judgments, was Parliament's understanding too. And I would like, please, to show, my lords, the following passages. First, please, at page 1459, where the committee, in paragraph 2.1 towards the bottom of the page, the committee highlights some perceived difficulties in the way of concluding reciprocal enforcement conventions with foreign countries. And what is said at 2.1 is, under the existing procedure in England, a foreign judgment is not enforced as such. An action has to be brought upon it and an English judgment obtained, emphasising the requirement of first obtaining an English judgment, and it is that which is then enforced. And then, my lord, at page 1460, please, at paragraph 3.1, again towards the bottom of the page, my lords, it says that the committee will set out a short review of what they call the present position regarding the recognition and enforcement of foreign judgments in England. And that is what it does, my lords, at page 1461. And at paragraph 5, paragraph 4 deals with recognition and judgment being recognised as conclusive. But at paragraph 5, having referred, as I said, to recognition in 4, the committee says this: if a foreign judgment fulfills the conditions required for its recognition in England as final and conclusive, and any sum of money certain is payable by one party to the other thereunder, the judgment itself creates in England a cause of action as for a debt.
And that means the foreign judgment.
That means
not the recognition judgment.
Yes, well, it's the foreign judgment which creates the
cause of action.
Yes, but again, if the foreign judgment fulfills the conditions.
Yes, but if you say, well, it doesn't fulfil the conditions until it's been recognised, well, then whether the foreign judgment creates a debt is neither here nor there, because you've got an English judgment which you can execute.
Yes, exactly. Exactly.
So what I'm gently suggesting is that the concept that the foreign judgment creates a debt doesn't depend upon an English court saying that the conditions for recognition have been fulfilled, but it depends upon the judgment intrinsically fulfilling those conditions, either because it does or because it's not in dispute that it does.
Well, what this makes clear is, first of all, the foreign judgment must fulfill the conditions required for its recognition.
Yeah.
That is the first point. And then the foreign judgment creates a cause of action as for a debt, because that, again, I'll come to that, because that was the necessary form of action. We'll come to that. And it's that which is then pursued in order to achieve an English judgment and money order, and it's that which is then enforced, as I've already submitted to my lords. But the committee goes on.
But I mean, just on the point my lord's been raising.
Yes, my lord.
I mean, isn't it the case that you get your English judgment, if you need one, in recognition of something that exists before that judgment is sought? I mean, that's what a judgment does. It enforces a claim which already exists.
Well, there are different, in relation to foreign judgments, the matter is tricky because English law wanted to find a way of a cause of action being available to the holder of a foreign judgment so that they could proceed here and get their English judgment. I'll come on to this when I come on to the obligation theory.
But the way they've done it is by recognising that the foreign judgment creates a debt.
My lord, no, that
Well,
with respect...
well, it gives a cause of action as for a debt.
Lord, that's not with respect quite right. What happens is that the foreign judgment is considered, just like what the commercial court has had to do in Maduro. The foreign judgment considers, first of all, whether the foreign court had international jurisdiction over the relevant defendant. It then considers whether the judgment is impeachable or not. At a point may be raised, a point not, but it has to be satisfied that the judgment isn't impeachable. At that point, the judgment achieves...
Sorry, during recognition, during the course of an action, the court, independently of the parties, has to consider whether the judgment's impeachable. Is it in an adversarial system?
My lord, well, in this sense, if an issue is raised by a defendant, then obviously the court has to resolve it.
Yes.
But if no issue is raised by the defendant, then the court will simply say, no issue is raised, and I therefore take it that it's unimpeachable. It occupies 2 seconds of the court's time.
A moment ago, you were suggesting that the court independently had to consider whether it was impeachable.
Yeah.
Well, my lord, yes, the court does have to consider it, but the court will assume it. The court will assume it is unimpeachable because the burden of proving impeachability rests on the party who wants to resist effect being given to the judgment.
Well, that's what paragraph 5 makes clear, that the burden is always on the supposed judgment debtor to defend this cause of action for a debt on the basis that the judgment is either out with jurisdiction or impeachable.
My Lord, yes, but that's not an issue. What's in issue here is that when the petition was presented, this foreign judgment had not been recognised. And as a matter of English law, it was of no legal effect. That is the stark position. That is the stark position. And because the foreign judgment had not been recognised, there was no debt, my lords, in English law, and there was nothing payable.
But that paragraph says there is a debt in English.
No, my lord, no.
There's a cause of action as for a debt.
My lord, that simply, I'll come on to this, that simply explains the basis for the action on the judgment at common law to obtain enforcement of the foreign judgment by way of an English judgment or order. That is what is being referred to. Well,
it may be a device, but it still is a device which, under which the foreign judgment itself creates in England a cause of action as for a debt.
As for a debt, my lord.
And that's an English law cause of action.
Yeah, has to be an English cause of action.
Well, precisely.
Yes, it has to be.
It has to be, because you don't get judgments from English courts unless you've got a cause of action.
Yeah.
But a cause of action pre-exists the obtaining of the judgment. You can have a cause of action without getting a judgment.
Yeah.
Lord, yes, but what's being referred to here is effectively the form, the basis, the reason for being able to enforce one's foreign judgment, if it's recognised, so as to obtain an English judgment and order. And the reason why, as for a debt, and we'll come on to other cases when I come on to the obligation theory, is because that was the only means of being able to have your cause of action in the 19th century. Yeah. And that was the theoretical action. So, yes, the cause of action, as my Lord Sells said, must be pre-existent, but not the debt. The debt itself, the actual debt, is only arises as a matter of English law once there is an English judgment, an English money judgment, and once the foreign judgment has been recognised.
That debt isn't based on the foreign judgment, it's based on the English judgment.
Because that's the only possible debt, my lord, yes. Yeah. That is the only possible debt. Because, my lord, I'm going to come to this.
Is that the debt that is then identified isn't a debt on the foreign judgment.
My lord,
it's a debt on the English.
My lord, in a nutshell, the cause of action as for a debt is a legal fiction.
Okay.
It is a legal fiction which enables a cause of action to be brought on the foreign judgment in order to generate an English judgment, which then gives rise to a debt. Lord, I'm going to come to this, which is the obligation theory in due course. But what is made clear, as your lordships will see, when I take you through just a couple more passages in the Greer report, is that the only way to enforce the foreign judgment in the broad sense is, as Dicey Rules 45 and 46 state, by the action at common law. What ST does is say, here's the theory for the action at common law, but we use it to generate a new right to be able to proceed to bankrupt Mr Drelle and bypass the action at common law. And that was never the purpose or intention.
Can I just check, you criticise the cause of action as for a debt as a sort of 19th century legal fiction.
Yeah.
What is the cause of action if someone goes out today to obtain recognition of the foreign judgment?
Lord, the cause of action is as set out in Dicey Rule 46. So one goes along,
but what is the cause? Is it as for a debt, or is it?
Well, that's a very good question, but that's the theory, because the Court of Appeal, for example, in Adams and Cape Industries, thought that there was some notion of comity behind it, and then we get forward to the Supreme Court in Rubin, when Lord Collins, together with Lord Sumption and Lord Walker, explain that the obligation theory is purely theoretical and historic. In other words, they attach no significance to it other than that it was put forward at the time to explain how it was you could bring a claim in the available forms of action which existed in 1870 before the Judicature Acts of 1873 and 1875 abolished the forms of action. But it's a good question your lordship raises, but it doesn't, whatever the theory is that allows one, and obviously we accept one can, that allows one to plead a claim to say, I am the holder of a foreign judgment, and I want it enforced in order to get an English judgment and an English payment order. Whatever the theory is, doesn't really matter, because that's what the holder of a foreign judgment can do. And if they satisfy the English court that the foreign court had international jurisdiction over the defendant, and the court reaches the conclusion the judgment is not impeachable, and it's not for a fine, and it's final and conclusive, then the result will be, whatever the theory, my lords, behind the action.
Theory does matter.
Yes.
You say it doesn't matter, it does matter.
Well, my lords, what it doesn't do is it doesn't give rise to a separate right and a separate entitlement in ST to bypass dicey rules 45 and 46 and proceed directly to petition for bankruptcy when no English court, and there's been no decision, has recognised this foreign judgment.
But surely it creates some form of cause of action or right to proceed to an English court to get a judgment. And what is an issue in these proceedings is what is the nature of that substantive right. I mean, English courts don't go around giving judgments if people don't have substantive rights. So there must be some form of substantive right. And the question is, what form does that take in this case?
My lord, the substantive right, with respect, is not an issue. I do not suggest that the holder of a foreign judgment does not have a substantive right to come to the English court to have it recognised or enforced. Of course not.
But what's an issue is whether it's as for a debt. Because when you get to the Bankruptcy Act, you've got to have a debt at the time of your petition.
Well, my lord, yes, but that demonstrates the point starkly, which is that what ST are doing is taking the reason for the foreign judgment holder to be able to go down the only route available to enforce the judgment in this jurisdiction, the only route available, as made clear by the cases, as I'll come to in further course in the Greer Committee, and Dicey, to say that somehow allows them to bypass the action on the judgment, even though what it is they want to do, my lords, is enforce that foreign money judgment.
Well, you'll no doubt come to the CN participation analysis of whether it is enforceable.
I will, but I'm going to come to that in my favour. But in that case, my lords, there was already, as your lordships know, a debt. And as was said in that case, the arbitration award confirmed the existence of the already existing contractual debt. Here, there is no debt in English law until there is an English money judgment. Sian was not concerned with the enforcement of foreign judgments in England.
But I mean, there isn't it seems to me there has to be an underlying substantive right.
Yes.
And I think you're accepting that.
Yes.
And it will be to a definite money sum, because that's what if you want an English judgment, that's what you would ask the English judgment to give in your favour. So why shouldn't one describe the underlying substantive right as a debt?
Because what you're seeking to do is enforce the foreign judgment. You're asking the English court to say that this foreign judgment...
But forgive me, you're accepting that you can do that?
Yes.
Yeah. And that there is a substantive right that is being enforced?
Yes, and that is your right as the party with the benefit of the foreign judgment. Right. And you say to the English court, I have a foreign judgment. I want to obtain an English judgment and an English payment order. And I can satisfy the court of my entitlement to that because the foreign court had international jurisdiction and because the judgment's not impeachable, where either the defendant raises the point and is dismissed or it's not raised. The English court then, recognition being the necessary primary concern, will recognise that. When it recognises...
Sorry, I'm so sorry to interrupt, but what it will give effect to, surely, is a substantive right to payment of a definite sum. That's the order that the English court would make, reflecting the nature of the right which is being sought to be enforced.
The English court will give a judgment. Say the foreign judgment is for £1 million. The English court will say, the foreign, or find, the foreign judgment is recognised and enforced, and here is a judgment for £1 million.
Yeah,
yes.
precisely.
And then the...
So the English judgment will reflect the underlying right.
In effect...
Yes. And my question to you is, since the English judgment is pay £1 million, why isn't the nature of the substantive right which is being enforced likewise an obligation to pay a definite legal sum in the amount of £1 million in our example? And if that's true, why doesn't one characterise that obligation as a debt for the purposes of Section 267?
Well, because one starts with the proposition that foreign judgments have no effect in this jurisdiction.
I think you're being asked to start with a different proposition, and that is there is an underlying substantive right, and it is for a sum of money. And you're being asked to approach it on that basis.
But the substantive right, my lord, arises under a foreign judgment. And if the holder of the foreign judgment comes over to our jurisdiction, it has no effect. Nothing can be done with it, my lord. And the only way anything that can be done with it is inert. And what the foreign judgment holder has got to do is to bring a claim, if they want to enforce it, bring a claim on the action and then get your English judgment. There isn't then no debt. If there was a debt there and then, one could, it would be collapsing the foreign judgment, which is an adjudication of the authority of a foreign state, into an English judgment. There would be no recognisable difference. And one does, the starting point...
I wouldn't accept that it is collapsing the two. The one creates a cause of action, and you may or may not sue on that cause of action. You may not need to. If someone just pays the money, you don't need to get an English judgment.
That's true.
You get an English judgment where people don't satisfy an English cause of action.
That is correct, my lord. That is correct. But if one wants to have the foreign judgment have effect in this jurisdiction...
Well, that's what I'm picking you up on. It does have an effect. It creates a cause of action.
That's all it does. No, my lord. All it does, with respect, is to create the cause of action stipulated by the Dicey rules, which is the action at common law if one wants to enforce. That's the only thing it does, my lords. And I'm going to make that good by going on. But that is the only thing it does.
But that may be sufficient. I think it's being said on the other side, that's sufficient.
Well,
to create the cause of action. The cause of action is of the character I've been putting to you. That is a debt for the purposes of Section 267. That's the case that you're having to face.
Well, my lord, no, because then one is giving effect, in this case, to a foreign judgment which has not been recognised because no sum is payable. There's no debt. Even if you're against me and your lordship say there's a debt, nothing is payable under the that foreign judgment until the English court has recognised it. If your lordships were to conclude...
But I'm so sorry to pick you up on this again. You say nothing is payable, something is payable precisely because there's a cause of action.
Not here, my lord. No, my lord, with respect, not here. Because if there was something payable here, then the foreign judgment would be effective. Let me give your lordships an example. If there is something payable here, one might... The holder of the foreign judgment might seek to compel in some way payment. that is something which they cannot do.
Well, they can. They can go to the English court and get a judgment.
Well, my lord, yes. If they go to the English court and get a judgment which recognises and enforces that foreign judgment, yes, of course they can go and compel, because then they have available to them all the available remedies that an English judgment holder would have. But until that foreign judgment has been recognised, it has no effect. That is what Dicey and the authorities, my lord.
Except, I think even you're accepting it has the effect of creating a court.
That's all, my lord, it does. My lord, my lord, it's obviously, my lord, it obviously must have an effect, because otherwise one doesn't get to the common law action on the judgment, which is the only means by which one can enforce the foreign judgment. So one starts from the obvious proposition. If there's no effect, then obviously the common law action on the judgment isn't even available. So one's got to find some basis for having that action on the judgment available to the foreign judgment holder. And what was theorized in the 19th century, and I'm not criticising those judges, but what was theorized then at that stage of the development of the law, because one could only bring an action in the form of debt or a sumpsit, which was effectively, and in this sort of case, based on a debt. And you'll see when we'll see when we come to Goddard and Gray how Mr. Justice Blackburn expresses the matter. That was the form of action available, and hence the expressions debt. But if one is going ahead and saying that the holder of a foreign money judgment can present a petition, and as at the date of the petition that sum is payable, one is then giving legal effect to a foreign judgment which has not been recognized, my lords. And that is contrary to Dicey Rule 45 and Dicey Rule 46. And those are the clear rules of the common law since for at least 150 years, if not before. It's giving effect. Otherwise, you are giving effect to the foreign judgment. And otherwise one dispenses with recognition, one dispenses with the action on the judgment. And
well, not if you want all your money.
Well, my lord, no, of course not.
If you want a judgment for the whole money, which you can then go and execute, you've got to get recognition. On the other hand, if you want to queue up with everybody else who's owed money by your debtor in a statutory process under which you only get part of your money, you may bring a bankruptcy.
My lord, with respect, no, because there is no principled distinction between collective enforcement and individual enforcement. All are concerned with enforcement. All are concerned with giving effect to the foreign judgment. Lords, let me move on. In that quote from the Greer Committee, the committee goes on that an action can be brought to recover the sum of money due under the judgment, and unless the defendant in the action in England can establish that the judgment in question doesn't fulfil some one or more of the conditions necessary for its recognition in England, the plaintiff will obtain judgment in England in respect of the sum of money due under the judgment. So again, the foreign judgment has first to be recognised as final and conclusive, and making clear that enforcement of foreign judgments is by way of action on the judgment. And my lord, throughout the report, at pages 1461, 1462, 1463 and 1465, the committee...
So which pages, sorry?
My lord, 1461, 1462, 1463 and 1465, the committee refers to recognising a foreign judgment as conclusive, recognising, reflecting correctly that it's recognition that determines the status of the foreign judgment and gives it conclusive effect. And I go back, my lords, at this point to what was said in the Maduro board case, that it is recognition which determines the status and the effect of the foreign judgment. If the sum of money in this case had arisen under a contract debt between Mr. Drelle and ST, then the Russian judgment doesn't come into it, But the Russian judgment here is the sole source of the sum. And so until there's recognition, the Russian judgment has no status, hasn't been determined, and has no legal effect. That is what this court decided in relation to foreign judgments in that case. My lords, none of what was stated in the Greer Committee report about the only available route to enforcement being the common law action was considered to be controversial. My lords, and to foreshadow a point which I'm going to make good when I come to the 1933 Act, the registration scheme proposed by the Greer Committee and adopted by Parliament was a change of procedure, not substance. And so the concession made by my learned friend yesterday, in answer to my Lord Briggs, that one cannot petition on the basis of an unregistered foreign judgment is very significant. And if you
mean unregistered but registerable?
Unregistered but registerable. Oh, yes, of course. Unregistered but registerable. So he conceded that a judgment falling within the 1933 Act scheme cannot found bankruptcy proceedings unless it's first been registered. And that's a point which is of very great...
Section 6, I think, isn't it?
It's a combination, my lord, actually, of Section 2(2)(b) and Section 6. Section 6 prohibits no enforcement otherwise.
Is it no enforcement or is it proceedings? Sorry,
Well, no, my lord, Section 2(2)(b) says once the foreign judgment's been registered, then proceedings may be brought on it. And as my learned friend said in answer to my Lord Stephen's question, proceedings includes bankruptcy proceedings.
Right, but that's, I was remembering correctly.
You were.
Section 6,
Yes.
page 435, says no proceedings
yes.
for the recovery of a sum.
That's both. It's a combination of the two. Your Lordship is absolutely right. Combination of the two. But that is important.
So it doesn't say no enforcement. I mean, it's using a specific word, proceedings.
Yes, but proceedings include bankruptcy proceedings, my lord.
Yes, but that's the point, isn't it?
That is an important concession. Because
Well, it's obviously an important concession if we were looking at a registrable judgment, but we're not.
Well, my lord, as I'll show you, lordships, it's an important concession in relation to the common law position,
Right.
because the Greer Committee, and I'll just headline it now, the Greer Committee said that what they were proposing was a change only of procedure, not any change to substantive law. I'll come back to that point when I come to it. And indeed, my lord, on page 435, just picking up my Lord Sales's point to me, 435, of course, section 6 is headed foreign judgments which can be registered not to be enforceable otherwise. My lords, these materials which I've shown your lordships, including other authorities and academic work cited in our written case at paragraph 20 at page 73, demonstrate that recognition of a foreign judgment is not a mere formality.
Did the Greer Committee give consideration to bankruptcy petitions,
No, my lord,
proceedings?
No, my lord, they did not.
And when you say that they only change of procedure, not of substantive law, they might have changed the substantive law, mightn't they?
My lord, not in...
So far as for registrable judgments, you have to register them before you can bring a bankruptcy petition.
My lord, I'll come to that. I'll show you, lordship.
Yes.
Well, what?
Well, I mean, that may not have been the position before the 1933 Act.
That's right. That is right, because all you had were different types of registration schemes under the 1868 and 1920 Acts. But the committee regarded that the approach to enforcement was simply a change in procedure. In other words, what they were doing was substituting for the action at common law a process of registration, a scheme of registration. And I'll show you, lordships, the passages. And therefore, the concession of my friend is important, because if he accepts, as he does, that bankruptcy proceedings cannot be based on a registrable, unregistered foreign judgment, then it makes no sense, I'll develop this in due course, for bankruptcy proceedings to be based on an unrecognized foreign judgment. My Lords, what I've shown, Your Lordships, as I've said, and as set out in our written case, as I said, demonstrate that recognition is not a mere formality. It is the essential condition, not only in being able to succeed in the action on the judgment and obtain an English judgment, but also it is the essential condition for the foreign judgment to have any legal effect in this jurisdiction. So with respect, my learned friends are wrong when they submit at paragraph 87 of their written case, page 39, without reference to authority, that recognition is an entirely formal process. It isn't. My Lords, ST also submit...
Have you finished with the Greer report?
I'm going to come back to the Greer report. So the answer is temporarily...
I'm going to ask you a question about paragraph 8, but tell me when would be a convenient time.
Would your Lordship...
1463.
I may be coming to that. Let me just...
Yes, I mean, you may be. That's why I don't want to interrupt. If
No.
We're going to come back to it. I'm happy. No, I may well come back to it. I'm happy if your Lordship wants to raise the question. That recognition isn't just a formality.
Yes.
But according to the Greer report, it is just the court investigating what qualities or characteristics the foreign judgment already has, rather than applying any kind of discretion of its own as to whether to recognise it. In other words, it suggests that the recognition process is simply a court investigation into pre-existing characteristics.
Well, my Lord, the foreign judgment is always going to have pre-existing characteristics, because the foreign court will have already had whatever jurisdiction it had.
Yes.
And that international jurisdiction over the defendant is tested by looking at our domestic rules of private international law. And equally, if the foreign judgment is infected with fraud, or if there's something else which infects it such that the English court, applying its own rules, would consider it offended against natural justice or public policy, then yes, inevitably it has those things. But it has no legal effect, as was said in by Lord Lloyd Jones in the Maduro board case. This court said it. It has no legal effect, and the issue of recognition must be considered. And as Professor Briggs said, recognition is the necessary primary concern, and Lord Roger in Clark and Fennoscandia agreed with that. The House of Lords agreed with that. So it isn't a mere formality. There has to be, before one gets to saying, here is a judgment which has an effect which I want to profit from, there has to be first recognition of that judgment. That is what the House of Lords decided, and that is what the Supreme Court decided in those passages, my Lords, that I've shown you. My Lords, ST also submit that the purpose of recognition is equally well served by the bankruptcy court when it decides whether to make a bankruptcy order. That's to say, after, obviously, the petition has already been presented. And it was repeated in a slightly different way yesterday by my learned friend, when he submitted that in the case of a bankruptcy petition, based on a foreign money judgment to pay an amount due, it falls to the English bankruptcy court to consider whether the foreign proceedings resulting in that judgment were conducted in accordance with English views of substantial justice. My Lords, that submission is wrong for two reasons. First, since recognition, as I said, is what gives legal effect to a foreign judgment, then if recognition is to be determined by the bankruptcy court, it comes too late, because the critical time for the purpose of being able to present a petition is the time of presentation of the petition as mandated by section 2672, and I'll come back to that point. My lords, secondly, if the bankruptcy court is being asked to determine whether the foreign judgment has legal effect and that it's conclusive between the parties, then it is engaged in doing precisely that which it has no power to do, or at any rate must not do. That is to say, establishing rights or liabilities.
But it doesn't do that. It simply asks, is there a dispute about this which must first be resolved? It being, as I understand from the Greer report, the burden on the putative debtor to raise any such dispute.
Well, my lord, with respect, that's not right, because the bankruptcy court, if it's being asked to consider whether a foreign judgment should be given legal effect and should be recognized, is engaged in a process of adjudication in relation to the foreign judgment holder's claim that he has something which he can enforce, that he has a debt which is payable as at the date of presentation of the petition. And that is precisely, my lord, what your lordship and my lord, Lord Hamblin, held in Sian at 1201. We can look at it, please, at page 1201. My lord, at paragraph 33.
Yes. Does not require any adjudication.
Yes, but my lord, if the bankruptcy court is engaged in considering whether a foreign judgment has legal effect, if it's engaged in considering what status the foreign judgment has, to quote the words of Lord Lloyd-Jones in Maduro, then, my lord, it is necessarily engaged in considering or involved in an adjudication of the claim of the holder of the foreign judgment to be able to enforce his foreign judgment, whether he has a debt on which he can petition, and whether it is immediately payable or at a future time certain. Because if one is saying that the debt is immediately payable, one is necessarily, my lord, in the absence of an English judgment, saying that the foreign judgment has legal effect, because it can't be paid.
With respect, it doesn't sort of square with what the bankruptcy court routinely does in this situation. The petitioner would come to court and say, look, I've got this foreign judgment for a money sum. I say it's prima facie has the characteristics which would, if necessary, get it recognized. The established law is that if somebody wants to challenge that, usually the putative debtor, he puts up a defense to that and says, no, it's either not made by a court of competent jurisdiction or it's impeachable. Now, the bankruptcy court doesn't adjudicate on that question. If it thinks there's a real dispute about it, it just refuses to make a bankruptcy order and sends you off to court to get your recognition judgment. It's not engaged in a process of adjudication. Indeed, the creditor who gets the bankruptcy order still has to prove his debt.
Well, my lord, I respectfully beg to differ, because there are no instances, no cases produced by my learned friends of where the bankruptcy court, no cases produced to my lords, where the bankruptcy court proceeds directly to bankrupt on the basis of an unrecognised foreign judgment. What was referred to below were two cases, a decision of a district judge and a decision of His Honour Judge Pearl, which were examined and assessed as not being helpful by my Lord Justice Snowden, as he then was, for the reasons which he gave in that judgment, and which I respectfully adopt. And nor, I might add, are there any cases, examples that we've been able to find of where a holder of an unregistered foreign judgment has simply gone along and said...
That may or may not be so, but going back to my lord's question as to the nature of what the bankruptcy court does.
But not...
If one takes an ordinary domestic contract claim,
Yes?
if the person being sought to be made bankrupt on the basis of a debt said to arise under that contract disputes on serious grounds
Yes.
that there is a contract debt, the bankruptcy court doesn't resolve that. It simply registers the fact that there is a serious issue to be tried, and the case then goes off to be adjudicated in another court. Is that not what happened?
Your Lordship is absolutely right. Couldn't agree more in the case of a contract debt.
So,
But this is not...
why, so forgive me just then to make the point, why isn't it the same model in relation to what is said to be a debt arising on the basis of a foreign judgment?
Because foreign...
The actual adjudication as to whether it's a foreign judgment which, according to substantive rules of English private international law, will be recognised, will be a matter which will be adjudicated if there's a dispute about it elsewhere, not in the bankruptcy court.
Well, Lord, the answer is as follows. There is a distinction between contract debts and foreign judgments. Foreign judgments are exercises of foreign state sovereignty, and that authority of the foreign sovereign ends at the borders of the foreign state. We have special rules in relation to foreign judgments, and that they are only given a legal effect in this jurisdiction. Dicey 45 and 46, and the passages I've taken my lords to in decisions of the House of Lords and Supreme Court. The foreign judgment is only given legal effect if there is first recognition. That is called, as Lord Rogers said, the primary concern. It is not a procedural point, it is a substantive point, my lord. And if one wants to use the foreign judgment as a sword by way of enforcement, to obtain the fruits of the foreign judgment in a commercial sense, then one must first bring the action on the judgment and obtain your English judgment. And if the bankruptcy court is being asked to determine whether recognition, the primary concern, a substantive matter, should or should not be accorded to the foreign judgment, then I respectfully submit and maintain my submission that the bankruptcy court is involved in adjudicating the right of the foreign judgment holder. This is no mere procedural thing, it is substantive. And therefore, they are doing what my lords said should not be done in Sian, and doing also what Lord Hoffman, of course, mentioned in White and Eckhart Marine. And could I just invite your lordships just to turn that passage up at 1296, please, when his lordship, in paragraph 26, page 1296, said, winding up is, as Lord Justice Brightman said in Lyons Brothers.
So, sorry, which... Where are we?
I'm so sorry, Lord. It's paragraph 26,
26.
Just below letter G.
Yes, got it. Thank you.
That winding up is, as Lord Justice Brightman said in Lyons Brothers, a process of collective enforcement of debts. The creditor who petitions for winding up is not engaged in proceedings to establish the company's liability or the quantum of the liability, although liability and quantum may be put in issue, but to enforce the liability. Just pausing there. So the first point is that a creditor who petitions is engaged in a process to enforce the liability. And therefore, in the case of a foreign judgment, is something which cannot be done in accordance with Dicey Rules 45 and 46, unless one first has achieved recognition by the English court saying, yes, this judgment has legal effect, and an English payment order. But it's the same point. If recognition, or since recognition, is a substantive matter, if that's left to the bankruptcy court, then it is, I respectfully submit, doing precisely that.
But the petition debt is just the trigger for the bankruptcy. It's not in seeking to enforce that claim. The claim will have to be made during the proceedings, like everyone else makes a claim.
Well, my lord, with respect, no. When a creditor issues a bankruptcy petition, as my lord, Lord Justice Snowden, as he then was, said in the Court of Appeal below, they are engaged in a process of collective enforcement or collective execution. That's the start of the process. And as my Lord Justice Brightman said in Re Lyons Brothers, and as Lord Hoffman confirmed in White, and as my lords also have said, that when one petitions, one is engaged in a process which is to do with collective enforcement and collective execution. My lords, where the foreign judgment alone provides the basis of the liquidated sum relied on by a claimant for his bankruptcy petition, then the question whether that foreign judgment is impeachable or not, or should be given effect, legal effect, and recognised, does require adjudication of the applicant's claim for the reasons I've said. And therefore, my lord, in this case, because the English court had not first recognised, at the very least, had not recognised the foreign judgment, the bankruptcy court, ICC Judge Burton, had to approach this case on the basis that ST was a holder of a foreign judgment which had not been recognised and therefore had no legal effect, and to boot, which had not been enforced. And my lords, your lordships will recall, I hope, the 5 points I submitted which arise from the common law reflected in Dicey Rules 45 and 46, that the foreign judgment has no direct operation or legal effect in the jurisdiction. Secondly, can only be given effect by the two routes set out in the Dicey Rules. Thirdly, is only ever given effect via the intermediation of the English court, the necessary precondition being recognition. Fourthly, that it won't be recognised and enforced unless the foreign court had international jurisdiction and is unimpeachable. And fifthly, that the rules draw no distinction between the different types of foreign judgments. My lord, those 5 points make clear, we submit, that ST's attempt in paragraph 62 of its written case at page 32 to draw a distinction between enforcement of a supposed debt arising under the foreign judgment and what it calls execution of the foreign judgment is misconceived. For the purpose of Dicey Rules 45 and 46, it is a distinction, as we say in our written case at page 99, paragraph 104, without a difference. My lords, the various different methods by which a claimant seeks ultimately to obtain the fruits of its foreign money judgment, be they execution, collective or individual, enforcement, collective or individual, or howsoever, are all examples of that which under Rules 45 and 46 cannot be done unless and until the foreign judgment has first been recognised and given legal effect in this jurisdiction and enforced in an action on the judgment. So it's paradoxical, we say, my lords, when at page 32 of the bundle, paragraph 62 of my learned friend's written case, ST submits what may not be done is execution of a foreign judgment, as if it were an English judgment. My lords, in the context of Dicey Rules 45 and 46, there is no principal distinction between individual enforcement and execution and collective enforcement and execution. All are processes of enforcement and execution available under various and different English processes and procedures. And that, my lords, is precisely the point that Lord Justice Snowden, as he then was making in the Court of Appeal below at paragraph 64, page 150, and with respect, he's plainly right.
My Lords, I now turn to the 1986 Act and the question of petitionable debt. Your Lordships will appreciate that it follows from what I've already submitted to your Lordships, that there is no debt, true legal debt in English law, and nothing payable in English law because the foreign judgment was not recognised and enforced. But, my Lords, before I address ST's arguments in paragraphs 22 to 32 of its written case, at pages 22 to 23, there are three matters on which I want to touch. First, relevant principles of statutory interpretation. Secondly, the relevance of the Court of Appeal's reference to the revenue rule. Thirdly, the timing stipulated in section 2672 of the Insolvency Act, that there's got to be a qualifying debt at the time the petition is presented. My Lord, first interpretation. There is no definition of debt or payable in the 1986 Act. That's common ground. And so, my Lords, it wasn't surprising that the 1986 Act should draw on principles from the wider law, as my Lord, Lord Justice Newey said below, at paragraph 44, page 144. My Lords, the reading of a statute in conformity with the existing common law is uncontroversial. And as is stated by Benyon, Lordships can turn it up at 1342, at 25.1, an act has got to be read and applied in the context of the general body of law into which it's assimilated. Ordinary rules and principles of the common law will generally apply to and may impliedly qualify the express statutory provisions. My Lords, we rely on everything that is stated on pages 1342 and 1343, and the dictum of Mr Justice Biles at the bottom of page 1343, that it was a sound rule to construe a statute in conformity with common law. Or, if I may respectfully adopt a vivid expression used by the Deputy President extrajudicially, the legislation must be knit into the fabric of the law. My Lords, it is an effect of this principle that the court, in certain cases, is required to construe general words contained in a statute as being impliedly limited. And it's the case that statutes are drafted on the basis that the ordinary rules and principles of the common law will apply to the express statutory provisions. And as well, having regard to the general presumption against the abrogation of a common law rule by statute, as referenced in Benyon 25.8 at page 1344, and Benyon 25.9 at page 1345, it is obvious that Dicey Rules 45 and 46 are not so inconsistent with or repugnant to the provisions of the 1986 Act that the two cannot stand together, nor that those rules cut across the legislative scheme or undermine its legislative purpose. And, of course, no such submission was made to your Lordships. And the rules and the 1986 Act for petitioning plainly are harmonious, because that is evident from the fact that ST could have done what it should have done, that's to say, start its common law action. It then could have obtained its judgment, and if there wasn't satisfaction of that judgment, it could have then chosen, as it did, to petition for my client's bankruptcy. My Lords, by contrast, ST's submission that the effect of section 2672 is that a sum awarded under an unrecognised foreign judgment may found a petition has the effect of bringing about a fundamental change to the common law as it was and as it was understood to be prior to the enactment of the 1986 Act, as reflected in the Greer Committee report, which you've seen, because that provided only for enforcement by way of the action at common law, and said nothing to challenge or edit or amend or delete anything that is said in Dicey 45 and 46. And as my Lords, your Lordships will well know, what the famous dictum of Lord Devlin in Wilkinson's case
cited, for your Lordship's note, at the bottom of page 1346, it's a well-established principle of construction that a statute is not to be taken as affecting a fundamental alteration in the general law unless it uses words that point unmistakably to that conclusion. The common law should not be altered by a mere sidewind. And as stated by Lord Simon of Glaisdell, in the Black Clawson case, you don't need to turn it up at 545F, clear and unmistakable words will be required for the abrogation of a long-standing rule of law, himself citing what Mr Justice Devlin said in Wilkinson. And then 2 lines, my Lord, below that at G, any ambiguity must be resolved in such a way that the rule is not abrogated. And my Lords, the principle that the common law should not be altered by a mere sidewind applies also to statute, as noted at Benyon 26.7 at page 1346. My Lords, the second matter which I want to touch upon is the revenue rule. It would have been understandable if, listening to my learned friend's submissions yesterday, the impression was gained by your Lordships that the Court of Appeal had equated a foreign judgment with a foreign revenue claim. That is not what they did, and that is not what our case was, nor what our case is. The revenue rule provides a neat illustration of how the provisions of the 1986 Act, specifically section 2672, and the meaning of the word debt and payable, take their meaning from the common law and our rules of private international law, as we set out in section B4 at page 79 of our written case. And it provided a good example, because although the revenue rule and a foreign judgment are obviously different, nevertheless they share, as Lord Justice Newey put it at paragraph 42 at page 143, a similar root. And, my Lords, we rely on the way his Lordship expressed it also at paragraph 43 at page 144, and also how Lord Justice Snowden, as he then was, put it at paragraph 65 at pages 151 to 152. My Lords, in short, debt in the subsection payable, obviously debt doesn't include a revenue claim. A revenue claim isn't payable, nor does it include, therefore, a sum payable under a foreign judgment which, as a matter of substantive English law, has no legal effect because it has not been recognised. My Lords, that does not mean then that a foreign exercise of sovereign power can never be given effect, but whether in this jurisdiction, such as a foreign judgment, but whether it will depends on our domestic rules of private international law. And in the case of foreign judgments, it's those dicey rules 45 and 46. My Lords, the third matter I wish to mention to your Lordships, and it bears repetition, is timing.
Is what?
Sorry, my Lord?
Is what?
Timing, my Lord. Timing. In the sense of section 2672 requiring that there be the qualifying debt as at the time the petition is presented.
Well, it requires that the debt be payable at the time of the petition.
That's right, my Lord, yes. So the question of whether there is a qualifying debt which is payable at the time the petition is presented, whether immediately or at a certain future time, must be assessed at that time and not afterwards. My Lords, in the light of those three opening matters, Mr Drelle's headline submission is this. At common law, a foreign money judgment which hasn't been recognised, let alone enforced by the action on the judgment to get an English money order, has, for reasons I've given, no legal effect in this jurisdiction. It follows, therefore,
that any sum awarded under a judgment which has no legal effect cannot be a debt in English law, and certainly is not something which is payable, let alone immediately, or at a certain future time.
It's payable in Russia.
Yeah, but that
It's
doesn't...
payable in Russia from the time of the decree.
Certainly, my Lord.
Not enough.
My Lord, we don't dispute that it's payable in Russia, but that's
Not enough.
It's not enough, my Lord, no, because when one's talking about a foreign judgment, the rules which I've already mentioned to my Lord in relation to adjudications of foreign states come into play. We do not, in our rules of domestic international law, treat foreign judgments in the same way as English judgments. And the Russian judgment, my Lord, does not obligation-wise come over, but I'm going to come on to the obligation theory in due course. My Lords, from nothing, that's to say the Russian judgment having legal effect, comes nothing. My Lord, therefore, a creditor resorting to bankruptcy proceedings as a means of enforcing payment, and those are the words used by Mr. Justice Blackburn in the Schalson case. You don't need to turn that up, but that's para 23 for your note at page 1151, and I might echo the dicta of Lord Justice Brightman in Re-Lines Brothers, which you all have seen, must first have his foreign judgment recognised and enforced here. And my Lord, that's important because even if ST is correct that there was an immediate obligation on Mr. Drelle imposed by the Russian judgment, and that this Russian obligation followed Mr. Drelle over into this jurisdiction when he came here, and that he continued in some way to be bound by it. Nevertheless, the only remedies available for ST in this jurisdiction are remedies under English law. And our domestic rules of private international law, as set out in Dicey 45 and 46, required recognition of this Russian money judgment in any event, and that it be enforced by an action on the judgment if it was to be used as a sword, and that was and is so irrespective of whatever obligation ST says Mr. Drelle was under. My Lords, ST seek...
I do apologise for interrupting, but you said it a couple of times. You said earlier on, one is coming along with a nothing, and you now said that the foreign judgment, you get nothing, nothing comes from nothing. And so that is back, and I suppose we've been over this ground, as to whether the foreign judgment does create an underlying substantive right in this jurisdiction.
Well, my Lord, it creates the right to bring the action at common law, but that is all. Because this is why...
And is there any authority on that basis, rather than analysing it on the basis of it creating a cause of action in debt, is there any authority for that proposition?
Yes, my Lord, Dicey Rule 45 is the short answer, and the cases that refer to it, and the various dicta and decisions of this court and the House of Lords, which I took your lordship to, about, which I won't repeat. And it's paragraph 21, my lords, of our written case.
But if we're just looking at what debt means under this section, in some sense, which is this part of your submissions, the general purpose of this section is to enable someone who has an immediate or immediate payable in the future debt to start this collective process on the basis that if the debt is undisputed, then it suggests that the debtor is insolvent and ought to be put in through a bankruptcy process. For that purpose, the court's perception that there is a qualifying debt is met if it's something on which, without there being any real bona fide dispute, he could go and get summary judgment for that sum of money from a court. Now, if he's got a foreign debt, albeit as yet unrecognised, never mind registration for the moment, then unless there's a bona fide dispute about the jurisdiction of the foreign court or something going to its impeachability, why isn't it in the mind of the statutory drafter or parliament, depending how you look at these things, just the same? This is someone who, without there being any dispute to the contrary, can just go off to court and get a recognition judgment because there's no dispute as to the terms of recognition. Why shouldn't that be as good a debt for starting off bankruptcy proceedings if there's no dispute as to its recognizability and still a determination not to pay it as a purely English debt?
Well, because it's a foreign judgment, my lord. And when it comes to foreign judgments, we have specific rules of private international law embodied in DICE Rules 45 and 46, which require and mandate, as confirmed by decisions of this court and the House of Lords, that the foreign judgment has no legal effect. And because, until it's been recognised, and that the only thing that a foreign judgment holder may do is to have the foreign judgment recognised or bring the action at common law. And I've shown, my lord, 45 DICE and 46, and I've also, my lords, taken you to the other matters. And I might just, in this context, refer your lordships respectfully to page 70 in the bundle, paragraph 6 of our written case, and we give citations as well. The rule about foreign judgments not having direct operation, or to use Professor Briggs's words, legal effect, or to use Lord Lloyd Jones's word, effect, which obviously is legal effect. At 6, the rule is founded on the principle that judicial adjudication is an exercise of state sovereignty, and state sovereignty ends at the border of the state. Thus, the first rule of foreign judgments is that they have as such no legal effect in England. For foreign judges, this is an answer in part to my Lord Doherty's point to me, foreign judges have no authority in England, except where Parliament has provided otherwise. Foreign judgments cannot be enforced in England by execution, and no person is in contempt of court or otherwise in peril in England if she fails to do what she's been ordered to do by a foreign judge. That's a general principle of international law. My lords, ST seeks somehow to escape this conclusion by erecting an argument in paragraphs 22 to 32 of its written case at pages 22 to 23 of the bundle, to the effect that under section 2672B, there is a petitionable debt if there is an obligation which is enforceable in an English court and which would constitute a debt because it was for a liquidated sum. My lords, that's wrong, and I'm going to show your lordships that it's wrong because it's contrary to particular provisions of the 1986 Act and the Court of Appeal's decision in McGuinness, a case relied on by ST and not contended by them to have been wrong in any respect. My lord, the relevant statutory provisions are, first of all, section 267 at 445, as your lordships will have seen, and section 382 at page 451. And my lord, these provisions were considered in McGuinness's case, which your lordships find at page 784 of your lordship's bundle.
Sorry, you said section 382,
my lord.
Yes.
Which I hope is at page 4.
No, you've got the right page.
Ah.
I'm just reminding myself what it says.
Lord, yes.
Well, I'm sorry, I missed the McGuinness reference.
That's 784, my lord.
Thank you.
And I don't know whether it's possible on your lordship's screens to keep open. Was that technologically too advanced?
No, we can't.
Oh, fantastic. So it would be very good if your lordship could have open section 382 at page 451, and also McGuinness at 784.
There we can.
My Lords, the issue in McGuinness's case, and no doubt my Lord, Lord Briggs may recall, was whether the liability of a guarantor under a particular clause of the guarantee created a debt for the purpose of section 2672B. The Court of Appeal held that the proper construction of the guarantee was that it was a conditional payment obligation on the guarantor, which had been well established on the cases going back many, many years, created a liability in debt. Your Lordship may recall there were 4 types. There's a see to it type guarantee, you have a conditional payment obligation, an indemnity, or concurrent liability under the loan. And it's only a conditional payment obligation or concurrent liability under the loan that would give rise to a debt. My Lords, at page 791, Lord Justice Patten considered at paragraph 12, section 322, and then rule 1213. And he then goes to paragraph 14 on that page. So a bankruptcy debt, not a petitionable debt at this stage, defined therefore includes not only a liability in a debt properly so called, but any claim for damages, whether in contract or tort, including a contingent or future liability. It does not matter whether the debt or liability is liquidated or remains to be ascertained. The extended definition in section 3823 includes both. And then, my Lords, at paragraph 15, his Lordship noted that the qualifications for petitioning as a creditor are, to use his words, more restricted because of the terms of section 267. And then, my Lords, at paragraph 16 on page 792, could I invite your Lordships to read paragraph 16 to yourselves? So debt doesn't include liability, doesn't include, therefore, the definition of liability. The two remain distinct. So, my Lords, ST's argument in paragraph 32 at page 24 of its written case, that Mr Drelle was under an obligation or liability to ST in money or money's worth, that was enforceable in an English court, and that therefore, since it was an ascertained sum, it constituted a debt, ignores what the Court of Appeal held in McGuinness. It wrongly ignores that the dominant provision for determining what may be the subject of a petition is section 267, and specifically section 2672.
The ST's position is that it is a liquidated sum.
Well, Lord, yes, but that's only part of the requirement. That's to say an ascertained sum. ST's argument, my Lord, proceeds on the basis of, 1, an obligation, 2, it being enforceable, and then it being a liquidated or pre-ascertained sum. There's no dispute that there is a liquidated sum, in the sense that it's 2 billion rubles. My Lords, secondly, ST ignores that obligations and liabilities in money or money's worth are not debts under section 267. And it also ignores that section 2672B requires that the sum is payable immediately or at some certain future time. So, again, in response to my Lord Doherty, even if the sum is pre-ascertained, it still cannot be payable within section 2672B unless there is an English law obligation to pay it, which requires, as I've submitted, in the case of a foreign money judgment, prior recognition and then an English payment order. Lords, briefly in relation to my learned friend's submissions based on McGreevy.
So you said it requires an English law obligation to pay. What about a debt under a contract governed by some foreign law?
But, Lord, yes, but here we're talking about foreign judgments. I'm talking
so long as you're not making the...
No, I'm certainly no, because I'm not contesting at all that there may be a sum due under a foreign contract where the proper law is French law.
Yeah.
Absolutely, that's not the issue. The issue here is foreign judgments. My Lord, as far as McGreevy is concerned, so far as that case is concerned, it's of no assistance to ST for the reasons given in our written case at paragraph 93, page 96, and for the reasons given by the Court of Appeal in the judgment of Lord Justice Newey at paragraphs 51 to 52 at page 147. My Lords, I now turn to the third out of four topics, the 1933 Act. My Lords, the purpose of the 1933 Act was not to alter the substantive principles that apply to the enforcement of foreign judgments at common law. We can see that from the report of the Greer Committee at page 1460, second line down. So far as the position in England is concerned, which they had already which was then being described over the page, which I took my Lords to, they say at the top of the page, the change suggested by the committee is one of procedure rather than substance and involves no radical alterations to the present position. And then, my Lords, at page 1471, please, under the heading, the principles followed by the present committee in framing their recommendations. It was stated, my Lords, at paragraph 18.2, a third of the way down, as follows. In the arrangements to be made in return for reciprocal treatment for the recognition and enforcement in the UK of the judgments of foreign countries, the existing principles of the common law should be followed in matters of substance. So, my Lords, the 1933 Act was modelled on the existing common law, and hence Lord Collins noted in Rubin, don't need to turn it up, but I'll give your Lordships the reference, at paragraph 5, page 1121, that the Act substantially reproduces the common law principles. My Lords, my learned friend yesterday conceded, I give your Lordships the reference transcript, page 73, lines 11 to 22, and page 74, lines 5 to 12, that a holder of an unregistered foreign judgment was not entitled to present a bankruptcy petition.
If it was registrable?
Of course, yes, my Lord. My Lord, just to be clear, unless a foreign judgment falls within one of the reciprocal arrangements concluded between this country, the UK, and a foreign jurisdiction, then one doesn't get into, obviously, registration. It is, as the Greer Committee notes, and this is clear from the Act, an Act based on reciprocity. So when I talk about registered, it can only be in relation to, my Lords, a judgment which is registrable. He conceded that an unregistered foreign judgment wasn't entitled to found a bankruptcy petition. The holder of such an unregistered foreign judgment had to have it registered and that it not be set aside under Section 4. My Lord, that is in an important concession. It is different from how the case, your Lordships will know, was put by ST until yesterday. And I just give your Lordships the reference, the grounds of appeal, paragraph 29, at page 1914, and my learned friend's written case at paragraph 95, page 41. My Lord, all that remains of ST's argument in relation to the 1933 Act is that registration under the Act and the action at common law are two different systems. Lord, since, however, the 1933 Act was intended only to effect a change of procedure, and it was modelled on the common law, that must mean that one cannot also petition on the basis of an unrecognised foreign judgment. And there's also the further point that it would be very odd if the holder of an unrecognised foreign judgment was in a better position by reference to being able to petition for bankruptcy than the holder of an unregistered foreign judgment. And that would have come as a great surprise to the Greer Committee if the registration scheme that they were proposing and which Parliament effectively adopted unchanged, in order to make matters simple and in order to encourage countries to sign up to reciprocal treaties, had left the holders of registrable foreign judgments worse off in that regard than those holding non-registrable ones. And they're worse off because they have to take a step before their foreign judgment is given legal effect.
I mean, mustn't take this recreation of common law apart from procedure too far, must one? Because one undoubted effect of the Act was that once you've got registration, you are actually suing in England on the foreign judgment, whereas if you get recognition, you're suing on an English judgment with its usual consequences in terms of execution.
Well, my Lord, the effect of registration...
Sorry, you're suing, you're actually executing on an English judgment.
That's right, or you're bringing bankruptcy proceedings within Section 2(2)b. Yes, but, my Lord, the person who registers their foreign judgment is only entitled to the benefits that Section 2(2) affords them if, of course, they've registered it, and if the registration isn't set aside under Section 4. Yeah. So, in other words, the only change, my Lord, is this, that the holder of a foreign judgment doesn't need any more to go through common law recognition and the action at common law, which is what the Greer Committee go on about. And they replaced that process because it wasn't very well understood by certain foreign lawyers and certain foreign courts. They replaced that process with a registration scheme, taking their cue, if you will, from the 1868 Act and the 1920 Act, which seems to have worked pretty well, although there were very few countries other than dominions which signed up to it. That's all that's happened. So that's why the Greer Committee were right to say that it's really only a change of procedure. But if you start from the proposition, as they say, that it's only a change of procedure, that there are no radical alterations to the common law, then if you accept the proposition that there can be no bankruptcy proceedings initiated if you've got a registrable foreign judgment unless it's registered, and then you transpose that over to the common law position, that you have your non-registrable, unrecognised foreign judgment, you ask yourself the question, well, what is it I need to do to put myself in the position as if I had a registrable judgment, which would then give me the Section 2(2) benefits? Answer, I've got to have it registered. And the equivalent at common law, that's to say exactly what registration was replacing, is the recognition of the foreign judgment and the action at common law. And so if one is conceding, as my friends do, that you can't bring bankruptcy proceedings based on a registrable, unregistered foreign judgment, and given, as I've said, the 33 Act changed nothing except procedure, no radical alterations, it wasn't a change of substance, then that strongly suggests, we go further, we say it means, if one wants to approach it coherently, and we respectfully suggest logically, that similarly, the holder of an unrecognised foreign judgment also cannot petition for bankruptcy. And, my lords, it was clearly the understanding of the Greer Committee that registration aside, the only other
alternative method of enforcing a foreign judgment was by bringing the common law action. And my lord, one sees that from the committee's observations in relation to draft clause 6, which became section 6 of the Act. And if your lordships please could go to page 1518, and just for your lordship's note, we don't need to look at it because it's the same. Clause 6, which became section 6, is at page 1480. But what the committee says in relation to clause 6, clause 6 takes away the right to bring an action at common law to recover money due under a foreign judgment which might have been registered. The committee thought that it was undesirable, that's in creating the registration process, to leave open the alternative procedure of enforcing by action on the judgment at common law. So what the Act did away with, in effect, was one of the two alternatives, the action at common law, leaving registration as the only option for the enforcement, including by way of bankruptcy proceedings, of a registrable foreign judgment. And we see that point, my lord, about alternatives, made also in Rubin, for your lordship's note, at paragraph 170, page 1129. My lords, turning to the Act itself, which I can now take much more briefly than originally planned, the combined effect of section 2.2 and 6 of the Act is, as my learned friend rightly conceded, that all the holder of a registrable foreign judgment can do with it is register it. Once registered, they obtain the rights set out in section 2.2, and that's at page 431. Your lordships will be familiar with it by now. Section 2, is entitled Application for and Effect of Registration of a Foreign Judgment, and we've seen that that includes taking bankruptcy proceedings because it falls within proceedings in sub B. And then my learned friend, as I've already mentioned, correctly said in answer to my Lord Stevens yesterday, in the references transcript, page 78, lines 9 to 11, that section 2.2b, I'm repeating myself, but included bankruptcy proceedings. So to put very shortly, registration is the gateway through which the registrable foreign money judgment must pass before the benefits of section 2.2 may be enjoyed. And my lords, for completeness, that proposition is also supported by section 9 of the 1933 Act, which your lordships will find at page 437 of your lordship's bundle. And the short point there is that section 9 of the Act prohibits proceedings for the recovery of a sum payable, so the same wording as section 6, being taken on judgments of what one might call recalcitrant states. That's states that no longer were affording reciprocity to English judgments in their jurisdictions. And the point of that was to encourage those recalcitrant states in due course to adhere to what they had originally signed up to. The effect of ST's submissions, as was the case, but now conceded, is that they would have been able to bring a bankruptcy, or the holder of a foreign judgment given by the court of a recalcitrant state would have been able to bring a bankruptcy petition. My lords, that interpretation of the 1933 Act and my learned friend's concession is supported by the Court of Appeal judgment in Rea Judgment Debtor. My lord, I had been proposing to take your lordships to that case to demonstrate that it was authority for the very proposition which has now been accepted, but as I've said, which until yesterday was very much in dispute. There was also a dispute, my lords, about what was decided in that case and its ratio. But that debate, though now seems to have become sterile, given that ST now accepts the proposition for which we had relied on the case, and which was relied on also by the Court of Appeal below. If your lordships think it will assist, I'm happy to take your lordships through the case to demonstrate the ratio of rear judgment debtor, that it isn't as narrowly as my learned friends had put it. That's to say that in the case of a registrable judgment, the only thing that the holder of such a judgment can do is register it, and then he obtains the fruits which are set out by Parliament in section 2.2 of the Act. But it doesn't seem, with respect, but I'm subject to my lords, that that's really necessary anymore, given what my learned friend Mr. Phillips said yesterday.
Very well.
My lord, on that basis, I can turn to the obligation theory. My lord, under ground one, as your lordships know, and as which has been a basis of questions put to me by my lords, ST relies heavily on the doctrine of obligation as expressed in the cases, and in particular, two cases of originally Goddard and Gray and Skibbsby, which your lordships noted, as we said in our written case, were decided on the same day, and in relation to Skibbsby, as I think my Lord Hamblin noted, Mr. Justice Lush had come along and Mr. Justice Blackburn had decided to let him peruse it, and Mr. Justice Lush had perused it and approved it. As we set out in our case, my lords, the obligation theory was devised by the judges at a time, judges of the Queen's Bench Division, at a time before the Judicature Acts, which abolished the forms of action, in order to explain, or to try and explain, within the confines of those forms of action, how it was possible that an action could be brought at common law to enforce a foreign judgment. Because the only available forms of action were in debt or assumpsit. And so it was necessary for there to be a pre-existing obligation, because otherwise the form of action just wasn't available. But, my lords, as is clear from Dicey Rule 45, and as follows from the decisions of this court in Clark and the Maduro Board, which I took your lordships to, and expressed by Professor Briggs in his works, which I also took your lordships to, any true legal obligation to do that which the foreign court has ordered arises only once the foreign judgment has been recognised. Now, my lords, ST argues that a foreign money judgment gives rise to a true legal obligation before and without recognition by the English court. My lord, ST is wrong for the reasons that I have submitted already and for the reasons which I will come on to. But, my lords, there are two preliminary points which arise in relation to how ST puts its case on what it calls the obligation principle. Now, my lords, it might be thought that in advancing this case, ST should provide, or be able to provide, legally coherent answers to two pretty fundamental questions. And those two questions are these. First, does this supposed obligation arise as a matter of English or foreign law? And secondly, does it arise for all foreign judgments or only those which are unimpeachable? My lord, with respect to ST, and as I'll show your lordships, it has no legally coherent answer to those questions. Lord, in relation to the first question, what's the law of the obligation? ST says that it's a Russian law obligation which is enforceable by the English courts, similar to a contractual obligation governed by Russian law. And I give your lordship the references, paragraph 50 of my learned friend's written case at 29, paragraph 56 of their case at 31, and paragraph 4 of the grounds of appeal at 1907. My Lords, the proposition that the obligation to which a foreign judgment may give rise is a foreign obligation enforceable by English courts is wrong and contrary to authority. In the Court of Appeal in Owens Bank at Bracco, could I invite your Lordships please to go to page 873 in that case, part of the judgment of Lord Justice Parker. His Lordship says...
Sorry, so this is Court of Appeal?
This is Court of Appeal, my Lord. What happened? The Court of Appeal decision was left... I'm going to come in due course to the House of Lords. The Court of Appeal decision was left undisturbed, and nothing that Lord Justice Parker said, which has been referred to in many cases, was doubted by their Lordships above. My Lords, on that page, at 3 lines below letter C, it is pointed out by the editors of Dicey and Morris that the right which the plaintiff seeks to enforce in such proceedings, that's the action at common law, is a right created and defined by English law and not by foreign law. Thus, in order for the foreign judgment to be enforced in this country, it is essential that the foreign court should have had jurisdiction over the defendant, not in the sense of the foreign law, but according to our rules of law. Then going on, and the defences which may be pleaded by the defendant in an action on foreign judgment, such as that the judgment was obtained by fraud, are themselves creatures exclusively of English law. As I said, my Lord, that decision, those dicta were left unchallenged and undisturbed in their Lordship's house. And with respect, what his Lordship state is obviously right. And indeed, one would have expected, if ST was right, that this was a Russian obligation, for Lord Lloyd-Jones not to have said, in the Maduro board case, you don't need to turn it up because I've shown it to your Lordships already, but for reference purposes, 161, paragraph 161, top of 726, if ST was right, you wouldn't have expected Lord Lloyd-Jones to have said in that case that the status of a foreign judgment is left to be determined in accordance with the domestic rules on the recognition and enforcement of foreign judgments. And similarly, at 169, my Lords, at page 728, letter E. Nor, my Lords...
But, I mean, can I just ask you this?
Yes.
It might be said that actually giving the answers that you say are given in Owens Bank in the Court of Appeal to your 2 questions doesn't affect ST's case for the purposes of this appeal. And it doesn't matter that the course of action arises as a matter of English law, nor that the substantive elements of that course of action are defined by English law rules of private international law. It remains the case that there is an obligation, so defined, to pay a liquidated sum.
Lord, let me answer your Lordship's question in this way. Lord, what I'm dealing with now is ST's submission that what was posited as the theoretical basis for the only way one could enforce actions on, the only way one can enforce foreign judgments at common law, namely the action on the judgment, somehow gives a right to petition, even though the foreign judgment has not been recognised and given legal effect by any court in this jurisdiction, as at the date of presentation of the petition. That's what I'm dealing with. My Lord, my opening salvo, as it were, is in relation to the 2 points which I outlined just now, which is that in advancing this novel theory, that the obligation theory has a life beyond being a theory to explain how it is one can enforce a foreign action in our courts, it would be considered useful if ST could explain what is the law attaching to the obligation in question. My Lord, what I'm dealing with is that their case is, in the references which I gave, my Lords, that the obligation is a Russian one,
What I'm submitting to your lordships is that as a matter of English law, that is wrong.
I think my lord understands that.
Yeah, I did.
His question to you was, which I would like to ask as well, I can have asked it rather more brutally, so what? Why does it matter that
fine.
that the appellants have made a mistake in their analysis of what law applies to this obligation, so far as concerns the outcome of the appeal?
Fine. I misunderstood my lord's question.
Right.
Fine.
Yeah.
I understand.
My lord has summarised that. I should have put it in those terms. That is what I was trying to get at. But just before you answer, could I also add to it this? Why isn't the Court of Appeal in Owens-Bracco against you? Because there, Lord Justice Jonathan Parker, in the section you asked us to read between C and D on page 873, says that the right which the plaintiff seeks to enforce in such proceedings is a right created and defined by English law. So it's recognising that there is a right that pre-exists going to court to get a judgment to enforce it.
But Lord, it's only within the context of the common law rules which I've made submissions on to my lords, and only in the context of the action on the judgment. And I forgive, your lordships, forgive if I repeat the point, that whatever the right is can only be brought before the court in this sort of case by an action on the judgment. And whatever else, there's a second strand, and the second strand is this, that whatever else a claimant or the holder of such a judgment may do, the status of the foreign judgment is that it has, as this court has held, it has no legal effect in this jurisdiction. It has no positive status until it has first been recognised.
The answer to your first question, answered yesterday in oral submissions, was the obligation arises as a matter of English law. That was what I understood the case that was being advanced, no matter what was said in the written case. And secondly, it seems to be supported by Goddard, Owens, the Greer Committee, and a number of our other authorities.
Well, my Lord, if that's what was said, I'll check that, I have no doubt, your Lordship, that was the case, then that's a change of the position. But it's
So what?
No, well, fine, but so what in one sense, my Lord, but so what in this sense, that if a party is going to suggest that the theoretical basis, what is only the theoretical basis for the only route to enforce a foreign judgment, somehow gives rise to a new right, another right, that's to say a right to enforce that foreign judgment by way of bankruptcy proceedings, then it ought at least be able to explain the basis for it. And the original basis, as explained, makes no sense. But I can move on, my Lord, from this point for... So sorry, my Lord.
I think so.
Yes,
I think no one is challenging the proposition that it doesn't make much sense to say it's a Russian law obligation.
Well, fine, but that was the position. No doubt the reason why they've now said it's English was because they read our written case or thought about it, whatever. But, my Lord, the fact is, it's important, because if it is an English obligation, then it's quite clear that our domestic rules of private international law and Dicey 45 and 6 make clear that the only route, the only way in which that English thing, call it obligation, call it cause of action, doesn't really matter. The only way it can be deployed if one wants to obtain the fruits, ultimately, of a foreign judgment at common law is by way of the action on the judgment. And as part of that, there is the necessary, prior, essential condition, which is that the foreign judgment must first be recognised, because without then, the foreign judgment has no legal effect. My Lords, I think then, having heard my Lords, I can skip over the second point, which was unimpeachability. I don't need to develop that, simply because it makes no sense if the judgment, if the obligation was a Russian one, to refer only to unimpeachable foreign judgments, because no doubt under Russian law, all Russian judgments have got to be obeyed.
Yeah, I mean, I thought you made the point very well on Lord Justice Jonathan Parker's judgment in Owens Bank and Bracco, page 873,
Yeah.
the defences which may be pleaded are defined by English law.
That's right.
Not Russian law.
I can move on.
So your cause of action is only a good one if those defences don't apply in relation to
Quite so. Exactly the point. My Lord, I can move on. My Lord, would that be a convenient moment?
Yes. So how are we doing? I'm grateful for the revised timetable. Although it's a little bit unclear, I've got 2:15/2:30 noted here. What does that
Well, I think I've had quite a few questions to deal with from my lords.
So is it 2:30?
I think
that we're looking-
2:30, yes.
2:30 and then 15 minutes for,
Yes, my lord.
for the reply. Yes, very good. We'll break there and resume at 2 o'clock, please.